in executive section for approximately 55 minutes discussing collective bargaining agreements, and there were no decisions made, and we can conclude the executive session. All right, so we're back on the agenda for the Committee of the Whole. And our next item is our mandatory ethics training. Okay.
How's that? Much better. Sorry, boy. I will go ahead and get the video if everyone is settled and get it started for you. It shouldn't be but about 15 minutes. And then we do have a form for you to sign, and that will take care of your obligation for 2014.
Hello, and welcome to the annual Cotw County Ethics presentation. At the end of today's presentation, you will be given an opportunity to sign an attendance statement electronically. This will fulfill your annual ethics training obligation. At the end of the presentation, you can re-review the presentation by using the back arrow. Just make sure to return to the end of the presentation to sign your electronic attendance statement. The law under Cotw County Code was passed by County Council and signed by County Executive Ed Fitzgerald in 2011 and has been amended since. The ethics law has three main purposes. First, to set minimum standards of ethical conduct for all of us. Second, to provide a process to disclose unethical practices. And third, to establish penalties for those who violate the ethics law.
She's got an elephant on her necklace. She's got an elephant on her necklace.
That was a bear.
It was an elephant.
The law under Cotw County Code requires that all employees, volunteers, lobbyists, and contractors undergo annual ethics training. Participants are also required to sign a statement acknowledging that they have undergone training and that they have read, understood, and agreed to the information in the ethics law. Again, you will be signing this acknowledgement electronically at the end of today's presentation. The county ethics law has two main components. First, it includes ethics laws that are contained in the Ohio Revised Code, or ORC. The ORC is the Ohio state law. The second component of the county ethics law is county provisions that are not in the state law, but is consistent with the Ohio Revised Code. These provisions contain additional restrictions that are unique to Cuyahoga County. The Ohio Revised Code prohibits the misuse of confidential information. This means that no one may disclose any information that has been designated as confidential. It does not matter whether the information is digital or on paper. Also in the state law is the prohibition against securing anything of value. This means that employees cannot use their influence to receive anything of value or even an offer of anything of value if that item could create a substantial or improper influence upon that employee. The key question is, could this create an improper influence on the decisions an employee is making? A vendor providing a promotional item to promote their product, like a pen or a keychain, most likely could provide a substantial or improper influence. But remember, it is always better to be safe than sorry. According to the Ohio Revised Code, those convicted of the misuse of confidential information or securing anything of value or the offer of anything of value are subject to all penalties and fines for violation of a first-degree misdemeanor. Soliciting or accepting improper compensation or gratuities for regular duties is also prohibited by the Ohio Revised Code. This means that it is illegal for an employee to request or accept compensation other than his or her county paycheck and county benefits to perform duties. In addition, the ORC makes it illegal for anyone to promise or give an employee compensation to perform his or her regular duties or to supplement an employee's compensation. The Ohio Revised Code also states that employees cannot solicit or accept gratuities for employment favors. This means employees cannot request or accept anything of value to hire or appoint a person to employment, to influence pay raises, duties, job placement, location, or promotion. Anyone convicted of soliciting or accepting improper compensation or gratuities for regular duties or employment favors is guilty of a first-degree misdemeanor, subject to penalties and fines, and disqualified from holding public employment anywhere in the state of Ohio for 7 years. The Ohio Revised Code also specifies political activity that is prohibited for some employees. Classified employees cannot solicit or receive contributions for political parties or candidates, be an officer in a political organization, or take part in politics other than by voting or expressing opinions. Classified employees also cannot make contributions to campaigns or office holders of the candidates for whom they work. Classified employees can register and vote, express opinions, make contributions to candidates they do not work for, circulate nonpartisan petitions, attend rallies, sign nominating petitions, have political materials displayed at their home or on their property, wear political material on themselves or on personal vehicles, and serve as an election day poll worker. However, classified employees cannot run for a partisan political office, circulate nominating petitions for a partisan candidate, be an officer in a partisan political group, or solicit any contribution for a political party or candidate. Classified employees also cannot sell political party tickets, take part in partisan political activities at the polls, or participate in a political action committee that supports a political party or partisan activity. Classified employees who participate in any of the prohibited political activities mentioned may be subject to termination from their county position. As mentioned earlier, some parts of the county ethics law are more restrictive than the Ohio Revised Code. One example of this is the employment of relatives. County employees cannot participate in any decisions involving a benefit to relatives, like hiring, appraisal, promotion, approving leaves of absence, etc. Employees cannot take any part in the hiring process if a full family member is an applicant for the position. Also, individuals can't accept employment in a department in which a full family member has supervisory authority. If an employee becomes related to a supervisor in the same department, that employee will be transferred. Remember, being related to an employee will not bar a job applicant from being hired unless the hiring authority is a full family member of the applicant. Employees cannot participate in decisions benefiting relatives, take part in the hiring process of a full family member as an applicant, or work in a department where a full family member has supervisory authority. But who is in your full family? According to the county ethics law, your full family includes your spouse, household member, children, grandchildren, siblings, parents, grandparents, all in-laws including grandparents-in-law, nieces, nephews, aunts, uncles, or first cousins. Full family also includes those for whom you provide half of their support, anyone who provides more than half of your support, or anyone claimed by you or your spouse as a dependent on your federal tax form. The law under the Cuyahoga County Code also prohibits the misuse of county resources. This means no employee shall use or permit the private use of county resources like vehicles, equipment, supplies, copiers, printers, telephones, mailing, or electronic communication. Also prohibited under the county ethics law is the misuse of official position. Misuse of official position includes representing your opinion as the official position of the county, or withholding a document that is considered a public record. Supervisors are prohibited from requiring that employees perform personal tasks that do not further the county's interests, perform work outside of the course of normal employment, or purchase goods and services for personal purposes. Some other examples of the misuse of official position include employees are prohibited from ordering goods or services without prior authorization, accepting county monies to attend a conference, then not attending the conference and not refunding those monies back to the county. In addition to the Ohio Revised Code, and the law under the County Code, certain conduct is prohibited by the Federal Civil Rights Act of 1964 and other laws. This includes favoring or discriminating against anyone because of their race, religion, age, ethnicity, gender, sexual orientation, disability, or political affiliation. Also, no employee may harass or make unwelcome advances that interfere with job performance, create a hostile work environment, or attempt to make a person's submission or rejection of advances a condition of their employment status. The law under the County Code also introduces the duties of the county's Inspector General. The Inspector General is the investigative officer for the county and conducts all investigations pertaining to the county ethics law. After an investigation, the Inspector General may issue letters of notification, admonition, censure, recommend suspension of an employee, suspend an organization's right to bid on or obtain county contracts, or refer violators for additional ethics training. In addition, the County Inspector General may refer violators to the Ohio Ethics Commission or to the appropriate law enforcement agencies. Under Ohio Revised Code, a whistleblower is defined as a person who reports possible crimes or violations. The Ohio Revised Code contains specific protections for whistleblowers. It specifies that no one shall take disciplinary action such as removal, suspension, transfer, demotion, or withholding of raise or promotion against a whistleblower. In Cotw County, whistleblowing employees who feel they have been retaliated against should consult their collective bargaining agreement, or CBA. Employees who do not fall under a CBA or whose CBA does not address whistleblower retaliation must file an appeal with the Personnel Review Commission within 30 days. Certain whistleblower responsibilities are detailed in the county ethics law. For instance, employees may file a report with their supervisor, or if they believe the violation is criminal, to the prosecuting attorney. If the employee believes the violation is a misuse of public resources, they may report it to the Inspector General. Employees are required to report any violations of the ethics law to the Inspector General within 5 business days of becoming aware of the violation. Any employee who has a conflict of interest shall report the conflict to both their supervisor and the Inspector General. The Ohio Revised Code also specifies a penalty for those employees who file false or frivolous complaints. Those who purposely, knowingly, or recklessly report false information are subject to suspension or termination. Under the county ethics law, employees are required to cooperate fully with any investigation by the Inspector General, the Department of Human Resources, or the Personnel Review Commission. Cooperation includes producing any information requested by the investigating agency, unless that information is not subject to disclosure. The law under Cuyahoga County Code also states that employees shall not engage in secondary employment that is incompatible with their county duties. Prior to accepting any secondary employment, an employee must complete a secondary employment disclosure form and submit it to both Human Resources and the Inspector General for advice. A secondary employment form must also be completed if an employee has any fiduciary, meaning legal or ethical relationship of trust, or pecuniary, meaning financial, relationship with an agency funded by the county. This obligation is not limited to a financial relationship only. Also, a secondary form must be submitted if secondary employment duties change at any time. Secondary employment forms are available on MyHR. If the Inspector General rules that an employee's secondary employment is in conflict with the employee's county duties, the employee will either terminate that secondary employment or face dismissal from the county. For additional information about the ethics requirement under the Cuyahoga County Code, it can be reviewed online at the Cuyahoga County Inspector General's website. Other human resources questions should be addressed to your human resources representative or by email at humanresources@cuyahogacounty.us. Congratulations! You have now completed your annual ethics requirement. Should you wish to review any of the slides in this presentation, do so now by using the back arrow. One reminder, all county executive employees have completed a nepotism statement and conflict of interest form in the past. If the information listed has changed, you must update this form. Forms are available on MyHR, and once completed can be sent to the Inspector General. By clicking the screen as directed, you are verifying that you have read, understand, and agree with the information in the law under Cuyahoga County Code. Remember, as always, falsification of a signature, including an electronic signature, is grounds for discipline. Thank you for your cooperation and for your work on behalf of the citizens of Cuyahoga County.
Okay. No, she just likes elephants. She's got a lot of them in her office too. Are there any questions? No, thank you. You signed those, right? And you take them. Yes.
Yeah, if you would all please sign your forms right now, I'll come and collect them.
I do have a question.
Yes.
The sexual harassment section looked like inappropriate behavior would only be considered inappropriate if it interfered with a duty or if it was unwanted. I mean, does that mean anybody could just go and like go up to Anthony here and no, it's not interfering with his work? I mean, it felt a little limited with
It's
that
really more,
definition.
we consider that more workplace harassment.
Okay.
So it does, we say workplace harassment because it's not just sexual, it's any inappropriate touching really falls under that. So if I'm an employee to an employee and then they're touching my shoulders and I feel it's inappropriate, I would actually fall under workplace harassment as opposed to sexual.
Okay.
Sexual has to do with someone that has some type of hold over your job.
Right.
And then you would, in order to keep your job, then you would have to do whatever they say.
Okay. Thanks.
You're welcome.
Was it?
Thank you.
There was an item on the Board of Control on Monday, and there were some questions about it, and we asked that it be held so that Mr. McCoof and Nate Kelly could give a presentation about it.
Madam President,
Go, proceed.
there is an item on Board of Control, CPB, that contemplates whether or not the county should hire bond counsel to help us evaluate a request, which was whether or not the county should participate in helping the city of Cleveland to issue a TIF for the benefit of the public square redevelopment. As a reminder, tax increment financing is a tool that cities use to redirect property taxes towards a specific redevelopment project. Currently, there is a TIF already in place on the Higbee building. The TIF proceeds are used for the redevelopment of the inside of the Higbee building. The city of Cleveland is contemplating whether or not to redirect some of those TIF proceeds, that would be property taxes that go to the city of Cleveland, to their general fund, and instead redirecting it towards public square. Because it is already an existing use or an existing TIF going to a private use, contemplated for a public use, for our participation, we need to evaluate it before we can make a recommendation to the county executive and county council for further consideration. And so we've requested to have bond counsel to help us with that. As a reminder, bond counsel is paid for from the proceeds of the issuance of bonds. So no funds would be expended for these, for this council unless a bond is issued, which would require to be approved by council and the county executive. So for our evaluation purposes, we've sought to have bond counsel to help us inform that decision-making and then make a recommendation to council and the executive.
No, and I just to clarify, sort of, Nate, got into it, is the county is not in the business of issuing TIFs, so we would not be the entity that would actually be issuing any TIF. That is a City of Cleveland process. That is a municipal function that the City of Cleveland already has in place for the Higbee building. The idea is that's being redirected toward Public Square. That TIF would be used, the theory at least, that's what the bond council would be analyzing, but that TIF would be used to service the debt for the Public Square improvements. So the county is not being asked to contribute financially to this. What we're being asked to do is to issue the debt because it's cheaper to issue it through the county. But it's not that we would be backing that debt or incurring any expenses in the process. It would be through the TIF proceeds that would go to service the debt and would pay the if they're issued, the bond council services.
Well, I think what concerned us when we saw this on the agenda, and as usual, we get this information by just seeing it on the agenda. Nobody tells us anything about it. I was unclear, and I'd been to a number of meetings about the Public Square project as to what the involvement of the county was. And had we had a clear, I think I speak for most people, we had a clear understanding of what the role of the county in the Public Square was, then we wouldn't maybe have these questions. So now you're coming in, all of a sudden we see on this agenda, we're paying for bond council, and we're like, well, wait a minute, what is this? And that was the confusion.
Understood. Madam President, we don't have a financial contribution to Public Square. At this point, we've been requested to evaluate issuing that TIF, and our request is to be able to have that council to help us inform decision-making.
So now, will this actually cost us this money, or will be paid out of the bond? Is that what you're saying? So this is a zero outlay for us eventually?
2 steps. At this time, it will cost us nothing. It will only the bond council will only be paid if council approves, if county executive recommends and council approves our participation as issuer of the bonds sometime in the future.
Yes, Mr. Brady.
I'm just trying to, understand this better. Who is requesting that we do this? I mean, help me out here. It's a city TIF. Is the city requesting this? Who is it? What is there an entity that's requesting us to take part in this? I'm just trying to understand it.
So I understand that the request of us has come as a combination of the city, eager to have the project done, and then folks from the Group Plan Commission that are helping to manage that project, its financing, and its construction. So we're looking at the request to see whether it makes sense for the county to participate as an issuer to help advance the project, or to even see if the county's participation would be helpful.
We're just going to analyze the request.
Correct.
Mr. Greenspan?
Great, thank you, Madam President. If we do move forward with this and the debt is issued, so I'm assuming a few things happen, we're being asked to back up the debt, correct? So if the TIF doesn't generate enough revenue to satisfy the debt obligation, we then are responsible for making up the difference in the deficit, the debt obligation?
As you've characterized the request, that would be the case.
Okay.
We don't know yet whether or not we would participate, and if so, how, or how that would be structured.
Okay. With that said, once again, I'm just assuming that this moves forward. There's apparently no exposure to us appropriating doing this. So I'm trying to now evaluate where we might have some exposure. If we do move forward with this and we do back up the debt, what then is the impact on our financial position as a county?
Perhaps it'd be better for me to give an example of a prior project as a model, not to say that we would follow that, but to give you an idea. So currently we have a reserve on balances for the Steelyard Commons project, where we've guaranteed the TIF for the financing for that project. shooting from memory, in that case, we have issued a credit enhancement. The proceeds go to the project. The payments in lieu of taxes go to debt repayment. So there's 100% coverage and then an additional 25% coverage. So the project has to ostensibly pay $1.25 for every dollar of liability to make sure that the county's in a very solid position. Furthermore, we have mortgages or other credits that make sure that we'll never be out a dime. But if I could extrapolate to say, probably the greatest downside would be the reserve on balance.
Okay, and the reserve on balance, and we talked about this with the $5 million guarantee that we just did a few months ago, does have a negative impact or has an impact on our 25% reserve limit. Just a general statement as we determined. The Steel Yard Commons project you mentioned, when was that project entered into?
2012 or 2013.
Okay. And so we do have a history of doing this, is what you're saying. This public square securitizing the debt activity.
That's a precedent, yep.
I'm sorry, this is a precedent, or the Steel Yard Commons?
Steel Yard is an example that I used.
Okay,
Yeah.
and this is a similar project to that?
It is similar insofar as your predicate about guaranteeing the TIF proceeds, trying to reflect how we would be characterized on our balance sheet to be helpful for your question.
And the terms that you mentioned for the Steel Yard, the 125% and the other guarantees, is it the expectation that this project, if we move forward with it, will have those same level of guarantees?
I'm not at a point where I can characterize those. We don't even have a valuation for the building yet to understand what the securities are, et cetera.
Okay, and outside of the city of Cleveland, well, before I go there, the Steel Yard Commons project, who are the parties to that transaction?
In what respect?
Well, if we're securitizing the debt, who are the parties of that agreement? Who are we behind?
I'm not prepared to answer that question accurately, but the city of Cleveland is involved. Okay. The Port Authority may or may not be involved. The private developer is involved, and I don't know what other financial participants there, but I can.
No, you answered my question. I should have stopped you when I heard the city of Cleveland, because the next question I have is this the start of a larger program where we may be asked by other political subdivisions, whether they be municipalities or school districts, to stand by their debts, and because our debt rating is maybe better than theirs, or we may be asked to step in? Is this, do you envision it going that route? Have we been approached by other schools, school districts, or other political subdivisions, cities, villages, townships to do this?
No, we haven't. I don't envision this to be a large formal program. We do have the infrastructure investment program, where we would use our investment portfolio to help strengthen suburban requests for investment, and that is limited only to the suburbs inside Cuyahoga County. City of Cleveland isn't eligible for that.
But that's a debt. That's a
school
debt.
boards and others.
That's a debt restructuring component, though. That's we're buying somebody's debt, and that's inside of our $820 million investment portfolio. But what I'm saying is, in this, why would a community not approach the county? If we're doing this with Cleveland, why would you pick any community in the county not want to come to us because we can get a better interest rate and have us stand by their debt?
In this case, I'd say that because tax increment financing, for the most part, is relatively rare. It's used for larger projects because it's diverting revenue that would otherwise go directly to the city for the benefit of a specific development project. So should the city reauthorize a tax increment financing deal for the benefit of Public Square, it's saying, all right, instead of taking all of the new incremental tax revenue from the redevelopment of Higbee Building, we want to make sure it goes to Public Square instead of to the city's general fund. Our intervention is just to accelerate that piece and then say, well, it is the Higbee building, it is a quality credit, and we expect that the likelihood of getting repaid is such, and for the benefit of Public Square, it's such that the executive and council would agree that we'd want to participate to hasten its development.
But there's nothing to prevent
Certainly
a
not.
community from presenting, absent of a TIF issuance, for us to stand by their debt or to issue debt on their behalf because we get a better rate.
Like, guaranteeing other cities' debt, is something that could be contemplated for a TIF. And revisiting the infrastructure fund, that investment is similar in that it does strengthen the city's ability, participating city's ability to borrow. The distinction, though, is that we're not out any actual capital. Whereas in a TIF, in a TIF scenario, we're not out capital, whereas an investment portfolio might be a little bit different.
Okay, thank you.
Any other questions? So the bottom line is, I have one question. How did we select this council? How did we select this bond council?
No, I think it was based on the underwriter, and everybody felt very strongly because of the tax implications in this deal and the experience with TIF, that Squire be the firm, and it wasn't necessarily for the bond council component of it, it was for the tax council component of it. You've seen us.
But I mean, how did you select this particular firm? Squire?
That was precisely the basis, is based strongly on the recommendation of the underwriter and the other parts of the team because of the tax component, so we went to them. It wasn't, there was no formal process, I guess.
Aren't we supposed to have a formal process for these things? Aren't we usually have a formal process for these things?
You could have exemptions from it. In this case, there's no expenditure of any county funds. I mean, to the county, it's a $0 transaction, because even if it's paid out of the bond proceeds, it's paid out of the bond proceeds that are coming from Cleveland. And because it's the nature of professional service, you have the exemption ability for that kind of retention.
Madam Chair,
Yes.
is Squire being represented by the City of Cleveland?
Sorry?
City of Cleveland, did they hire Squire?
They don't have bond counsel at this point, so I don't know who they would be hiring.
Okay.
But if we're the ones the bond counsel would be paid out of bond proceeds. If we're the ones, we would be the ones hiring the counsel.
Okay, any other questions? So this matter then will go back on the, is it Board of Control or for Monday?
The Contracts and Purchasing Board,
Contracts and Purchasing
CPB.
Board for Monday? All right, thank you, gentlemen. All right, any public comment unrelated to the agenda?
No, Madam Chair, there is none.
Okay, then we'll stand adjourned until 5 o'clock for our regular meeting.